Good morning. Now that everyone has joined us, I'm ready to start. Is everybody else ready to start?
Yes, sir.
Yes, sir.
All right, I call cause numbers 10,694 and 10,823. Each of these cases being styled the state of Texas versus Misty Dawn Doty. A silent bless you to Miss Fay.
Thank you.
The scheduling of this matter in the last day or so and the plea papers that have been presented indicate to the court that the defendant desires to enter pleas of true to a motion to revoke probation and a plea of guilty to a charge to unauthorized absence from community corrections facility, the state jail felony, and to make or enter those pleas pursuant to plea agreements between defense and state. Let me first, before calling for announcements, state for the record that these proceedings, these hearings are being conducted by remote video teleconferencing technology. We are using the Zoom protocol to do so. The hearings are also being live streamed on the court's YouTube channel. Both electronic aspects of this hearing are being accomplished in order to comply with the Texas Supreme Court's orders requiring same and the Office of Court Administration orders and directives also that we do so and that we provide the YouTube streaming of the hearing to allow the public to participate in the court's hearings as spectators. The Office of Court Administration has opined that that is necessary to comply with the open courts clause of the Texas Constitution. Just for the record, I do not believe that's what the open courts provision of the Texas Constitution requires, but nevertheless, we are complying in that fashion. Let me also announce that because these two matters are being heard electronically, that is by remote video teleconferencing technology, the court expressly prohibits any person from recording any portion of this proceeding electronically or otherwise, with the exception that the official court reporter who is on this hearing as well will record it, transcribe it, just as he would do if we were in an in-person proceeding. With those announcements and pronouncements, let me call upon the state. Is the state ready to proceed on the basis I've called?
The state's ready, Your Honor.
And is the defense ready to proceed on the basis we've called?
And ready, Your Honor.
Ms. Doty, you are, or let me ask it in the form of a question. Are you Misty Dawn Doty?
Yes, sir.
Ms. Doty, the state has filed a motion to revoke a probation previously granted to you. Have you received a copy of that motion to revoke that probation in cause number 10,694.
Yes, sir.
And do you understand that the state's motion to revoke probation alleges that you have previously been placed on probation in this case? It further alleges that you have violated the terms of that probation with particulars as to allegations as to how you violated that probation. It asks that your probation be revoked and that you be sentenced to the penitentiary or the state jail. Do you understand that's the allegations in that motion to revoke probation?
Yes, sir.
To the allegations in the state's motion to revoke probation, how do you wish to plead? True or not true?
True.
Then I want to turn our attention also to cause number 10,823, which is styled the state of Texas, which is also styled the state of Texas versus Misty Dawn Doty, and advise you that you have the right to have the indictment in that case read out loud to you here in open court. Do you wish to have someone read that indictment out loud to you?
No, sir.
Do you understand that that indictment charges you with a state jail felony offense of unauthorized absence from a community corrections facility?
Yes, sir.
To that allegation, how do you wish to plead? Guilty or not guilty?
Guilty.
Now, with respect to both of these causes that I've been talking to you about, first, I want to make sure that you understand certain rights that you have. First, you do not have to enter a plea of true to the motion to revoke, and you do not have to enter a plea of guilty to the new indicted case. You have the absolute right to enter pleas of not true and not guilty to those two causes. And further, you have the right to not have it used against you if you were to decide or choose to exercise those rights. Do you understand that?
Yes, sir.
You also have the right, with respect to a motion to revoke probation, to have a reasonable time to, which is usually presumed to be 10 days, or a minimum of 10 days. Let me pause and say, we have been having some internet connection problems. And so if our internet connection becomes difficult for you to see anybody else in the hearing, or to, since it's our internet connection, that may be a problem. If you have any problems seeing us, the court, or hearing what we're having to say, raise your hand or speak, and we will try to address that.
Yes, sir.
All right. As I was saying, you have the right to have a minimum of at least 10 days notice, presumably 10 days notice of the allegations in the motion to revoke probation. And you have the right to have a minimum of 10 days notice of the matters alleged in the indictment. It appears to the court that from docket entries and my own recollection, you have had more than 10 days notice of the allegations in the motion to revoke probation and in the new indictment. Is that your recollection as well?
Yes, sir.
Even though you've had more than the minimum time allowed, I will grant to you additional time to prepare for either of these proceedings before we went to trial on those proceedings. Let me also tell you that you have the right to have a jury hear your case with respect to the new indictment, that's cause number 10,823. And that's true even if you enter a plea of guilty to that charge. Do you understand that you have the right to a jury trial with respect to the new indictment?
Yes, sir.
Is there anyone from the sheriff's office in the same room with you?
Yes, sir.
I didn't see who was there. Whoever is there,
Yes, sir.
can you turn out the overhead lights?
Yes, sir, I sure can.
Thank you. All right. It provides us with a better visual of you, Ms. Doty. And the backlighting doesn't blur the screen in front of you. All right. Again, I was asking you if you understood that you had the right to a jury trial, and your answer is?
Yes, sir.
I have been handed documents in each of the two cases, the revocation case and the new indictment case, that says you're giving up the opportunity to have more time to prepare. And with respect to the indicted case in 10,823, it says you're giving up the right to a jury trial. Did you realize you were giving up those rights when you signed the documents entitled Waiver of 10 Days and Waiver of Defendant?
Yes, sir.
And is that what you still wish to do in each case?
Yes, sir.
Ms. Fay, your signature is on the Waiver of Defendant document in 10,823. Is that evidencing, well, it's actually your signature is on each of those waiver documents. Is that evidencing that you're joining your client in these waivers?
Yes, sir.
Mr. Smith, your signature is on the 10-823 waiver of defendant document. Is that evidencing the state's joinder in the waiver of the right to a jury trial?
Yes, Your Honor.
All right, I will accept those waivers and we will proceed. Ms. Doty, there are other rights and admonitions I need to discuss with you. And so let me begin by discussing the range of penalties that exist for a state jail felony like that which is alleged in 10,823. The range of penalties for a state jail felony runs from 180 days up to 2 years in state jail and carries the possibility that a fine could be imposed, and if imposed, in an amount not to exceed $10,000. Do you understand that's the possible range of penalties you face in cause number 10,823?
Yes, sir.
Now, I know I mentioned that I'm aware that there is a plea agreement in each of your cases. I do not have to follow the plea agreements, but at least with cause number 10,823, I must tell you if I'm going to follow the plea agreement, because if I decide not to follow the plea agreement, and I'm going to extend this to both cases, even though it only applies to 10,823. If I decide not to follow the plea agreements, then I will allow you, and the law will recognize a right in your favor to withdraw your pleas of true and your plea of guilty. And if so, if those things happen, we'll just start all over. Nothing that we've signed, that you've signed or said today would be used against you when we went to trial. But there is another side to that coin. The other side is this. If I do follow your plea agreements, first I will tell you that. And if I decide to do that, then that means all the terms of the plea agreement will be binding upon you. You will be bound to those terms. You will not be able to get out of those terms just because you might not like the terms anymore. Or you couldn't get out of the terms of the plea agreement if I follow it by appealing your case. And that's true, even though ordinarily there is a right to appeal. But the right to appeal, even from a plea bargain agreement, disappears entirely if a part of your plea agreement says you're giving up the right to appeal as a part of that agreement. Your plea agreement has that provision in both cases. Both plea agreements have that provision marked. So it means if I follow your plea agreement or agreements, you cannot appeal at all. Do you understand that?
Yes, sir.
Right, then let's go further, and let me ask you some questions I'm required by law to ask. First, are you a citizen of the United States of America?
Yes, sir.
Where were you born?
San Angelo, Texas.
My next question asks, do you consider yourself presently, that is at this time, to be mentally competent?
Yes, sir.
Do you know what's going on in these proceedings?
Yes, sir.
Have you been able to understand the charges and the allegations so that you could discuss those with your attorney and discuss the facts that surround those allegations and charges, as well as to discuss with her her opinion about the law and how the law affects or even is affected by the facts of your case? Have you been able to do those things?
Yes, sir.
Ms. Fay, do you believe your client is mentally competent?
I do, Your Honor.
All right, I accept that representation, and it's obvious to the court Ms. Doty is mentally competent, and so I make that finding. Ms. Doty, my next question asks, are you satisfied with the legal representation your attorney has provided to you in these matters?
Yes, sir.
And I think you know why I asked that question, but let me explain on the record. I asked that question not because I think you wouldn't be or shouldn't be satisfied, but instead just to give you a chance to let me know if for some reason you thought the attorney's work was deficient or legally ineffective, which would then allow me to take steps to try to get those deficiencies or legal ineffectiveness, if they existed, corrected before your case is finally disposed of. I also would tell you that since I give you the chance to let me know of any problems now, while I could still work to get those problems resolved, that effectively means you're not likely to be successful if you wait to some later date to say your lawyer didn't do a good job. In other words, now's the time to let me know if you have that thought so that we can work to correct any problems that might exist. Do you understand that?
Yes, sir.
And understanding that, are you still telling me you're satisfied with the legal representation your attorney has provided to you in these matters?
Yes, sir, I am.
All right. Then, excuse me, then next I turn to another area of inquiry, this one dealing with your decision to enter the pleas of true and plea of guilty. Because I'm required by law to inquire into this. And so I must decide if these decisions to enter these pleas are your free and voluntary decisions.
Yes,
So
sir,
let me
that's
ask you, has anybody threatened you, forced you, tricked you, or in any way tried to make you enter the plea of true and the plea of guilty to these respective cases when you would not otherwise do so?
No, sir.
Has anyone, I started to say, paid you or promised you anything of value just to get you to enter the pleas of true and pleas of guilty when you would not otherwise do so?
No, sir.
Are you telling me then that you're entering a plea of true to the motion to revoke probation and a plea of guilty to the new indictment because in truth and in fact you are guilty of the new indicted case, and thus you're also, the allegations in the motion to revoke are also true? Is that what you're doing?
Yes, sir.
All right. I believe those are all the questions I have at this time. Mr. Smith, you may proceed.
Your Honor, in each case, the state offers for evidence a document marked as State's Exhibit 1, each of those being this defendant's signed and sworn stipulation of evidence in its respective case.
No objection.
All right, Ms. Doty, let me talk to you about these stipulations. And I would tell you that at least in cause number 10,823, the state is required to produce some evidence tending to show your guilt, even though you plead guilty to that charge. And that's to ensure that a right that belongs to you in both of these cases is in fact provided to you. That right is your right to, the legal expression is to confront the witnesses against you, which essentially means you have the right to require the witnesses to be in court in such a way that you could see them and hear them as they give their testimony under oath. But the stipulation of evidence in each of these cases say you're giving up that right, and thus you're telling the state they don't have to bring their witnesses into court at all. Did you realize you were giving up the right to confront the witnesses against you when you signed the stipulations of evidence in each case?
Yes, sir.
The stipulations also, both of them also say that in their respective cases, you're giving up your right to remain silent and your right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. And instead, you are giving evidence against yourself because the stipulations of evidence, for one, say they are judicial confessions. And secondly, they admit that all of the material allegations set out in the motion to revoke probation in cause number 10,694 and all of the material allegations set out in your indictment in cause number 10,823 are true. That is, that you committed the offense and thus the violation of probation in these cases, just like it is alleged in the alleging documents. Did you realize you were admitting to the commission of the offense and the violation of probation when you signed these two stipulations of evidence?
Yes, Your Honor.
Now, there's another paragraph in each one of these stipulations that talks about court costs and reimbursement fees in the two respective cases. Did you realize there were paragraphs calling for you to pay $610 in reimbursement fees in the revocation case, and it would amount to $1,075.81 reimbursement fees and court costs in cause number 10,823. Did you realize those paragraphs were in this stipulation of evidence in these two cases?
Yes, sir.
All right, State's Exhibit 1, the signed sworn stipulation of evidence in each case is received as evidence in each case.
State rest, Your Honor.
Vince?
Rest and close, Your Honor.
It closes.
Ms. Doty, I'm again looking at your plea agreements. In cause number 10,694, the revocation case, the plea agreement says that you will enter a plea of true as you have done, and that will result in your probation being revoked and you being sentenced to state jail for a period of 2 years. It also provides that you will be ordered to pay reimbursement fees totaling $610, and you will be given back time credits totaling 191 days. I left out a provision. There's a provision saying you will pay restitution in the sum of $4,248. That's also in that plea agreement. Then finally, in that plea agreement, as is true in both plea agreements, there's the provision that I talked to you about earlier that says you're giving up the right to appeal. In cause number 10,823, the new indicted case, that plea agreement says you're going to enter a plea of guilty, as you have been doing, and that would result in a 1-year sentence to state jail with an obligation to pay court costs in the sum of $290, reimbursement fees totaling $785.81. There is another provision that I wonder if it is an error. It says that you will pay restitution in the sum of $290 as well, but there are court cost obligations totaling $290. And I do not see that restitution obligation in 10,823 also being set forth in the proposed judgment. So is that an incorrect provision?
Sorry about that. Yes, that's incorrect, Your Honor, and should be taken out of the written plea agreement. That wasn't part of the agreement.
Ms. Fay, is that your understanding?
That's my understanding, Your Honor.
Is it agreeable with the parties that I just interlined through that portion of the plea bargain agreement?
Yes, sir.
Yes, sir.
All right, I have done so. That still leaves financial obligations of court costs totaling $290, reimbursement fees totaling $785.81. The plea agreement says you give up the right to appeal, as we have talked about. And it also says that cause number 10,823 you will begin to serve that sentence when the judgment and sentence in cause number 10,694 has ceased to run. In other words, the new indicted case will be stacked on top of the revocation case. That's what I understand the plea agreement to say. That plea agreement also says, Ms. Doty, that you are entitled to 67 days of time credit in this 10,823. Now, those are my understandings of the plea agreements. Ms. Doty, do my understandings match your understandings of the plea agreements in these two cases?
Yes, sir, Your Honor.
And are you asking me to approve these two plea agreements?
Yes, sir, Your Honor.
Ms. Fay, have I stated the plea agreements accurately as you understand them to exist?
Yes, Your Honor.
And Mr. Smith, have I stated the plea agreements accurately as you understand them to exist?
Yes, Your Honor.
All right, I announce that I will accept and follow the plea agreements. And I note that by signing my name to them. And so, in cause number 10,694 and 10,823, each style, the state of Texas versus Misty Dawn Doty. Ms. Doty, based upon your plea of true in cause number 10,694 and the evidence stipulated to in that cause, I find that you have violated the probation previously granted to you in that cause. I find that therefore your probation should be revoked and you should be sentenced to state jail. In cause number 10,823, also based upon your plea, this one being a plea of guilty, as well as the evidence stipulated to in said cause, I find that you are guilty of the state jail felony offense alleged of unauthorized absence from a community corrections facility as alleged in the indictment. Those findings and judgments being pronounced, Ms. Doty, do you know of any legal reason why a sentence should not be imposed in these two cases?
No, sir.
Then following your plea bargain agreements, I hereby sentence you in cause number 10,694 to serve 2 years confinement in the Texas Department of Criminal Justice State Jail Division. I order you to pay reimbursement fees totaling $610, as well as restitution obligations totaling $4,248. And in that cause, I'll grant you time credits as per your plea agreement totaling 191 days. And then in cause number 10,823, also following your plea bargain agreement, I hereby sentence you to serve 1 year confinement in state jail, the Texas Department of Criminal Justice State Jail Division, and to further order that that 1 year sentence shall begin to operate when the judgment and sentence in cause number 10,694 in this court has ceased to operate. I assess the court costs in the sum of $290 and reimbursement fees in the sum of $785.81. Also grant time credits totaling 67 days in said on said sentence. All right, Ms. Doty, your thumbprint is required on each of these judgments and sentences, and it appears to the court that your thumbprint has already been impressed upon the proposed judgments. Did that occur as those documents were presented to you there in the Scurry County Jail?
Yes, sir, they were.
All right. Does anybody have any questions?
No, Your Honor.
No, sir.
Then those will be the orders of the court. We will be in recess and our hearing is concluded. Thank you.
Thank you.
Good luck to you, Ms. Doty.
Thank you.
Yes, ma'am.